Professor Lund, welcome to Constitutional Chats. And we would love to have you start with just some opening comments on the Second Amendment, its history, and just give us a little overview, and then we'll go to some questions.
Okay, thank you. It's an honor to be here for an audience a little bit different than the ones I usually talk to, which is a bunch of lawyers. And so it's a real pleasure to be here. I want to start just by reading the text of the Second Amendment. I'm sure most everybody in the audience is familiar with it. I'm going to read it just so you have that in your mind. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, because of the way the Second Amendment is worded, there's been a debate about whether it protects a private right of individuals to keep and bear arms, or a right that can be exercised only through militia organizations like the National Guard. That question, however, was not even raised until long after the Bill of Rights was adopted. Many people in the founding generation worried that the new federal government might use military force to usurp the role of the state governments and to oppress the people. English history suggested that this risk could be controlled by permitting the government to raise armies consisting of full-time paid troops only when needed to fight foreign adversaries. For other purposes, such as responding to sudden invasions or other emergencies, the government could rely on a militia that consisted of ordinary civilians who supplied their own weapons and received some part-time military training. The Revolutionary War showed that militia forces could not be relied on for national defense. The Constitutional Convention therefore decided that the federal government should have almost unfettered authority to establish peacetime standing armies and to regulate the militia. This massive shift of power from the states to the federal government generated one of the chief objections to the proposed Constitution. Anti-federalists argued that the proposed Constitution would take from the states their principal means of defense against federal usurpation. The Federalists responded that fears of federal oppression were overblown, in part because the American people were armed and would be almost impossible to subdue through military force. Implicit in the debate between the Federalists and the Anti-Federalists were two shared assumptions. First, both sides agreed that the proposed new Constitution gave the federal government almost total legal authority over the Army and the militia. Second, they agreed that the federal government should not have any authority at all to disarm the citizenry. They disagreed only about whether an armed populace could adequately deter federal oppression. The Second Amendment conceded nothing to the Anti-Federalist desire to sharply curtail the military power of the federal government, which would have required substantial changes in the original Constitution. Yet the amendment was easily accepted because of the widespread agreement that the federal government should not have the power to infringe the right of the people to keep and bear arms, any more than it should have the power to abridge the freedom of speech or prohibit the free exercise of religion. Now, a lot has changed since 1791 when the Bill of Rights was adopted. The traditional militia fell into desuetude, and state-based militia organizations were eventually incorporated into the federal military structure. The nation's military establishment has become enormously more powerful than 18th century armies, but it is no longer considered a threat to our liberties. Furthermore, 18th century civilians used the same kinds of weapons they kept at home for their militia duties. That's no longer true. The law has also changed. During the founding era, there were almost no restrictions on weapons other than attempts to disarm Blacks, American Indians, and British Loyalists. Another important legal development was the adoption of the 14th Amendment in 1868. The Second Amendment originally applied only to the federal government, leaving the states free to regulate weapons in whatever way they saw fit. There's substantial evidence that the Privileges or Immunities Clause of the 14th Amendment was meant to protect the right of individuals to keep and bear arms from infringement by the states, but the Supreme Court rejected that interpretation in 1876. During the 19th century, there were no federal gun control laws at all. Some states did enact restrictions, primarily laws against carrying concealed weapons, and they were mostly upheld against challenges under state constitutions. In the 20th century, gun control became more popular, particularly in the states. In 1934, Congress enacted the first major federal gun control statute, which led to a cryptic and ambiguous Supreme Court decision that didn't settle much of anything. After that decision, the lower federal courts rejected every Second Amendment challenge that came before them, often on the theory that the Second Amendment protects only a right of the states to maintain a militia. The Supreme Court refused to review any of these decisions, so the Second Amendment effectively became a dead letter. In 2008, the court finally issued its first meaningful Second Amendment decision, which struck down a ban on handguns in the nation's capital. It was called the Heller case, and in that case, a 5-4 majority ruled that the text and history of the Second Amendment showed that it protects a private right of individuals to have arms for their own defense. The 4 dissenters disagreed. They concluded that the Second Amendment protects only the right of the states to maintain a well-regulated militia. They also argued that even if the Second Amendment did protect an individual right to have arms for self-defense, it should be interpreted to give legislatures a great deal of deference in dealing with problems like violent crime. 2 years later, in McDonald v. City of Chicago, the court struck down a similar handgun ban at the state level. In this case, 4 justices relied on judicial precedents under the 14th Amendment's Due Process Clause. Justice Thomas rejected those precedents in favor of reliance on the Privileges or Immunities Clause of the 14th Amendment. But all 5 members of the majority concluded that the 14th Amendment does protect the same individual right that's protected from federal infringement by the Second Amendment. Now, notwithstanding the lengthy opinions in Heller and McDonald, they technically ruled only that government may not ban the possession of handguns by civilians in their homes. That holding, that specific holding, was not based on any evidence about the original meaning of the Second Amendment. It was based instead on the popularity of handguns in the 20th and 21st centuries. Both cases also endorsed a number of modern gun control laws. These included laws against concealed carry, against gun possession by felons, against unusual weapons like machine guns, and against guns in sensitive places like schools and government buildings. These endorsements were not explained or justified with any historical evidence. After these decisions, the lower courts upheld almost every gun control law that was challenged. Most of these cases relied on the endorsements in Heller or on the kind of deference to legislatures advocated by the dissenters in Heller. In June of this year, the court struck down a New York statute that allowed government officials to make it impossible for civilians to carry a handgun for self-defense. The 6-3 decision in Bruin relied on the text of the Second Amendment, which unequivocally protects the right to bear arms, and on the absence of any historical tradition of forbidding ordinary Americans to carry weapons in public. The court also repudiated the interpretive approach adopted by the lower courts after Heller. From now on, said the court, the government will be required to prove that modern regulations are consistent with the historical tradition of regulation that already existed when the Constitution was adopted. Unfortunately, the Bruin court did not follow its own instructions. It endorsed certain kinds of laws requiring a license to carry a gun without providing any evidence of any such licensing tradition. It also endorsed gun-free zones on the basis of a tiny number of supposedly analogous regulations from the 17th and 18th centuries. This suggests that the court is not really serious about adhering to the original meaning of the Second Amendment. In the future, I believe, the extent of our constitutional rights under this provision of the Constitution will depend largely on the policy views of the justices. That's an old story with lots of other constitutional provisions, and it's sad to see it happening again. All right, you can now hit me with questions.
Well, thank you. That was a great overview. And before Tova jumps in here, and I know she's got to go to class, I just wanted to ask, when you say that the court endorses certain restrictions, gun restrictions. How do they do that? Is it just in their opinion? They say they mention the restrictions and they say, we don't see anything wrong with this, or, I mean, how exactly do they
Yeah,
endorse?
that's basically correct. That's basically correct. Put it in legal terms. They said there's a presumption that these are valid. That means that it's a presumption that might be overcome somehow. But then in Heller, in another place, they just say that they approved of those regulations. So they basically say exactly what you suggested. They say, well, these regulations are out there and we don't see anything wrong with them. And the lower courts treat that as gospel, as though as precedent that has to be followed from a higher court, which in my opinion is wrong. It's not. It's not part of the holding in the case, and the lower courts are not bound by it, but they almost all think they are.
Okay. Well, Tova, I'm going to turn it over to you.
Great, thanks, Kathy, and thank you, Professor, for being on and giving us that overview. I just wanted to ask about the phrase "well-regulated." Like, it just seems interesting to me, since in the First Amendment, it doesn't say, we have the right to a well-regulated speech or well-regulated religion or something. So why do you think there's the phrase "well-regulated militia"?
Okay, well, the historical story for that is a little complicated. I'm just going to give a very simple version of it. The anti-federalists, or a lot of the anti-federalists, really did not like the amount of military authority that was being given to the new federal Congress, and they were worried about it. And the Second Amendment, by making this kind of praise of the militia, is giving a kind of rhetorical endorsement of that preference for the militia over standing armies. And I think that's all it does. It doesn't really have any legal effect because of the way the operative clause is worded. But I think it was put in there as kind of, you could say, a sop to some of the anti-federalists who were worried about too much federal military power. But of course, that leads to the next question, which I'm sure you were about to ask, Tova, which is, well, what does it add to the Second Amendment besides that? I mean, it's a little odd to start talking about the well-regulated militia if that reference doesn't have any legal effect. And I think the answer is that well-regulated doesn't just mean heavily regulated or more regulated. That's the way we tend to think of it. A well-regulated militia is one that's heavily regulated, so it'll do the right thing. But that's not the only meaning of well-regulated. Another meaning of well-regulated is not inappropriately regulated. So something that's overly regulated is not well-regulated. And I think the Second Amendment tells Congress and the country that there are certain forms of regulation of the militia, which Congress has the power to regulate the militia. Some forms of regulating the militia are not allowed. Congress, in Article 1 of the Constitution, Congress is given extremely broad authority to regulate the militia. And the Second Amendment says, okay, you've got broad authority. We're not going to tell you exactly how to exercise it, but there's one thing you can't use that authority to, and that's to disarm the people who would constitute the militia. And I'll just give you an example of the kind of regulation that the Second Amendment tells Congress you may not adopt. You can easily imagine that Congress would decide that all the weapons that people will need for militia duty shall be stored in a government armory. And if they're ever called up for militia duty, then we'll hand them out to them, but you can't keep them at home. And that's imaginable that Congress could do that. And the Article 1 of the Constitution could easily be read to allow that. And the Second Amendment says, no, that's not allowed. You may not disarm the people under the guise of a regular or in the form of a militia regulation. Does that answer?
Yeah, thank you. It's a really interesting train of thought. Has anyone tried to make the argument that the phrase well-regulated, like where are you getting this basis of some people interpreting it as being like not as regulated, and some people like, has there been a legal argument made in the courts over the definition of the phrase, or have the courts more ignored it and said that's more of like an adjective, as you were saying, and not really have any legal authority there?
Well, I made the argument in a brief in the Heller case, and the court just ignored it. At oral argument, interestingly enough, Justice Kennedy seemed to accept it. His oral argument it was a little garbled, as people often are when they're speaking extemporaneously, but Justice Kennedy seemed to understand the argument and accept it, but it didn't end up being adopted by the court. So one of the many problems with the Heller decision is they don't have a good explanation for the relationship between the militia preface and the operative clause about the right of the people. They just don't have a good explanation. And Justice Scalia's opinion tries to give an explanation, but it has a sufficient number of problems that the court has in Heller. The court essentially just said, well, we're going to move on to other questions here. The dissenters, on the other hand, relied very heavily on their opinion, based mostly on legislative history, what we would call legislative history, what people were talking about at the time, that it protects only a right of the states to maintain a militia. And that has fatal problems, I think, as a legal argument. But that four members of the court accepted that.
Right, thank you. And then just looking more at the language of the Second Amendment, the right to bear arms, I guess what is defined as arms? Does that just encompass like any sort of thing that could be used to defend oneself? What would the founders have defined it as? And today, like what has it sort of been applied to?
Well, the founders didn't need to define it, and they didn't. One thing that it's easy for us to forget is that there were just virtually no regulation of weapons in the founding era and up well into the 19th century. In fact, there was a law in Boston, I think, that told people you can't store a loaded cannon on your property inside a building. Well, that kind of implies that there were enough cannons. They thought they had to say something about keeping them loaded in your barn or whatever. Black powder was, which was used in all firearms at that time, is extremely volatile, extremely easy to explode accidentally, and so on. So there were a number of founding era laws which were essentially preventing fires from breaking out and so on. As late as 1843, an abolitionist newspaperman defended his office with a cannon. He had a cannon outside his office, in front of his office, as a warning to mobs not to come and try to lynch him, I guess. At least that's what was reported in the newspapers. So one of the questions that courts now have to answer, that nobody in the founding generation apparently gave any thought to, is what kinds of weapons are just too dangerous to be in civilian hands. And I think everybody agrees there are some that are just too dangerous to be left in civilian hands, starting with nuclear weapons, but also including anti-aircraft missiles, things like that. But the lower courts after Heller and before Bruin had quite a number of cases about this, but the Supreme Court has not ruled on any of those cases to put restrictions on certain kinds of weapons. There's some language in Heller that says that if they're commonly used by civilians, then they're protected and otherwise not, and gives machine guns as an example of something that's probably not protected. But again, that's what we lawyers call dicta, or just comments in an opinion that don't have legal force. So whenever the court does take up a case that specifically involves that, it won't be bound by that. although I think everybody expects that they will treat their own dicta as binding, even though they don't have to, just the way the lower courts have.
Yeah, that's very interesting. It seems like it would be very hard to draw the line between what is, accepted or unaccepted as arms, since weapons are designed by nature to kill people. What's to say that one weapon is too dangerous than another? Just seems like something that would be very difficult.
I
But
think you're right. It's going to be difficult to draw the line, but there'll be a lot of cases that will fall easily under one side of the line or the other. But drawing the exact line, I think you're right, will be difficult.
and what do you think that should be based on? Like when drawing that line, do you have any opinion on that?
Yes. In my opinion, that line should be drawn by an analysis that puts the burden on the government to show that that the civilian possession of certain arms is either a very slight burden on the I should say both a reasonable burden on the Second Amendment right and justified by a legitimate interest that would have been consistent with the purpose of the Second Amendment. Because the purpose of the Second Amendment, this is something on which Heller was correct, the purpose of the Second Amendment is to protect your right to defend yourself against, primarily in modern times, primarily against violence that the government doesn't protect you from. And so if the government takes away your ability to defend yourself, it should have a very powerful reason, and she'll have to prove to the courts that is very powerful, and that a minimum amount of infringement on your right will occur. Now, I'll give an example from the oral argument Bruin, the case that just came out in June. One of the questions that came up, that's the first case that decided that we do have a right to carry a firearm in public. First Supreme Court opinion that found that. And so one of the things they argued about at the oral argument was, well, can you carry it anywhere? Or are there some places you can't carry it? And there was these comments in Heller, well, sensitive places like schools and government buildings you can't carry. So they argued, well, is Times Square a sensitive place? Is the New York subway system a sensitive place? And lawyers were arguing about it, the justices were arguing about it. And Justice Alito came up with what I thought was a very sensible suggestion, which is a sensitive place is one in which the government gives you at least as much protection as you would have from your own weapon. And so he gave the example of buildings where there are magnetometers that make it extremely difficult for anybody to bring a gun into them, and where there's a sufficient police presence to protect you. So since 9/11, most government buildings have satisfied those criteria. But Times Square doesn't. The government isn't protecting you in Times Square. So Alito, I thought, gave a very interesting way to analyze that. And I think it's unfortunate that was not accepted by the court, because there's no trace of it in the Bruin opinion.
Well, thank you so much for that analysis. And then my final question is just looking internationally. It seems to me, at least, that the US is known to have particularly strong protections for gun rights, whereas a lot of other countries don't. I was in Morocco this summer, and I was telling my host family about sort of the culture of guns in America, and they were just shocked because it's not a thing at all in Morocco to have weapons, for individuals to have weapons. And I know that's the same in a lot of other countries. So I'm just curious if there's other countries that have protections for gun rights in their constitution, and why you think America has sort of a uniquely strong gun culture protection for gun rights.
Well, I'm gonna start answering that by telling you an anecdote. I was once on a talk radio show talking about the Second Amendment, And one of the listeners called in and said, well, I'm from England, and we think you're insane to have something like the Second Amendment. And I said, well, we have a lot of things that are different from England. The First Amendment, for example, you don't have the constitutional right of free speech or freedom of religion. So we think we've done okay with our own way of going here with freedom. So I think part of the reason that we have such a strong tradition of self-defense is part of it is just our heritage. It's been around, but of course England doesn't have that anymore. We were born out of a revolution in which freedom was extremely valued, and this is not very common around the world. It's just not common. People have constitutions. For all I know, you have the right to keep and bear arms in Russia, for all I know. But these constitutions often purport to guarantee all kinds of things that they don't really guarantee. There are things in our history that account for our strong tradition. I think, the mystique of the West, the self-reliance, the tradition of self-reliance, I think, is in our history is much stronger than in countries that have a history where democracy is relatively recent, and their cultural traditions are much more kind of top down. I don't want to use the word authoritarian, but top down. That's true in their legal systems and their political systems. We're just very unusual in having a cultural tradition of valuing the right of individual self-defense and the right of and the ability to be self-reliant. Tocqueville, who most of you are probably familiar with, he was a French writer who came to America to find out what was going to be happening with democracy, because we were the most democratic nation in major nation in the world at that time. And one of the things he said in his book, Democracy in America, was, if a tree falls down and obstructs the road, so people can't, drive their horses or their carriages on the road, in France, in the United States, all the people are nearby get together and get the tree out of the way. They cut it up or move it or whatever. In France, they just wait for the government to take care of it. And I think that was a profound observation about the difference between our culture and European culture more generally, and it's reflected in our attitude towards self-defense, I think.
Well, thank you so much for answering all my questions, and I will now pass on to Jewel and Jordan.
All right, hello, Professor. Thank you for being here with us today. A few quick questions to start. So first of all, do we have what would be the first example, or is there any example of early states regulation on arms? I know you had mentioned about the canon, but is there any instance where we see the states more aggressively regulating arms?
Primarily, as far as I know, I don't know what the very first one was. There were an occasional regulation of guns, even in the colonial period. But when you get into the 19th century, there was kind of something of a wave of laws forbidding concealed carry. And some of them went further and said you can't carry handguns at all in public. Those tended to be struck down by the state courts, not under the Second Amendment usually, but under their state constitutions. But these laws against concealed carry became quite common, and in at least two of the cases that went to the state Supreme Court, the court basically said, nobody carries their guns concealed except people who have up to something bad, that they're going to assassinate somebody or something. So what should happen is people that want to carry a weapon should act like real men and carry it out in the open where everybody can see it. And I think that was reflective of the culture of the time. So there was a fear of concealed carry in quite a few states, but in none of those states that I know of during the early 19th century was a ban on all carry of firearms accepted. There may have been one case in one state, but then it was overruled a few years later, I think. But that was the main thing in the early 19th century. After the Civil War, there was a lot more regulation of guns during the Reconstruction period, and then into the 20th century, a lot more.
And then you had mentioned about the debate going on between the anti-federalists and the federalists, and this concern of the national government being tyrannical, and the Second Amendment with the purpose of the people being able to actually defend themselves against government becoming tyrannical. That concept seems to be totally ignored, like thought of as unimportant among critics of the Second Amendment. But do we have some type of, where would you point to of the primary source, or one of the best places where you see that was their actual, one of the motivations for the wording of the Second Amendment?
Oh, that's just about all they talked about. It's just about all they talked about in connection with the Second Amendment publicly. The debate in Congress in the House of Representatives focused on whether or not to include a provision which was eventually dropped, guaranteeing pacifists, primarily Quakers, an exemption from militias. So the discussion in the founding period was almost entirely about the military use of the militia and its value in deterring federal oppression. One of the most striking statements, and among the most well-known, is in the Federalist Papers. Madison is responding to anti-federalist objections to the enormous military authority that was being given to the federal government. And he says, well, there's really no need to worry about that because first, the government, the Constitution is set up in such a way, the structure of government is such that will make it very hard for the federal government to turn tyrannical or be taken over by a despot or something like that. But he said, even quite apart from that, the whole citizenry is armed, and the federal government couldn't afford to raise an army sufficient to defeat the state militias, who will all be, their officers will all be appointed by the state governments. That's the one of the very few things that Article 1 does not allow the federal government to do. The officers have to be appointed by the state governments. And Madison said, yeah, good luck trying to oppress 3 million people who are armed and officered by men of their own choosing.
And with that answer, which is a strong answer, I wonder, when we think about the modern gun debate and the trying to find it in the words of the Second Amendment, find it in those words with the ability to heavily regulate. It's almost, I can't find in good faith the strong argument that there's any basis in legality of intense regulations. So I'm wondering, from the opponents of this, what have you heard?
I'm sorry, and there's something wrong with the sound system. Any legality to what? I just didn't hear you.
What's the strongest legal argument for for heavily regulating arms, when given what we've just talked about and the pretty clear purpose of the Second Amendment in the founding?
Well, I'm not sure I understood your question, but let me give an answer and see if it responds to your question. Some of the states actually had in their constitutions, some of the early states actually had in their constitutions a kind of right to revolution that said that people have the right to throw off an oppressive government, and they said that in their own constitutions. The federal constitution does not have that. What it does have, though, is a clause in Article 1 authorizing the federal government to use the militias to suppress insurrections. And it seems to me that if the Constitution authorizes the government to suppress insurrections, it must also authorize them to have the means of suppressing insurrections. And when that conflicts with the right of an individual to have a weapon, I think that that's going to have to come out in favor of the government with respect to weapons that could actually facilitate a revolution. So, you know, with our rifles and shotguns and handguns, we're not going to be defeating the 82nd Airborne. I mean, it's not going to happen. And if you think that the Second Amendment requires us to be able to defeat the Second Amendment, the 82nd Airborne, you're going to have to allow us fighter planes and anti-aircraft. That would just not do us any good in protecting against legitimate threats, most commonly from criminals. And it would make it very, very easy for irresponsible individuals to create a whole lot of havoc. So I'm not sure that responds to your question, but if not, try it again.
It was another interesting explanation, but within there pretty much there is an answer. I was wondering about my final question, the philosophy of the Second Amendment, and what you were talking about towards the end of Tova's final question about some of the nature of Americans and the nature of our country versus others. In the words, the right of the people to keep and bear arms. If you wanted to just, before Jordan asked his question, say what did that say about the American people? I mean, was that a great responsibility they seem to have? Was there any other meaning behind that maybe we miss sometimes?
Well, yeah, I'll just expand a little bit on what I said before. You know, for the Supreme Court's first decision actually upholding a right of individuals to keep and bear arms was in 2008. And through almost the entire 20th century and well into the 21st century, the courts just pretended that the Second Amendment didn't exist, or they interpreted it in a way that made it nothing. Now, I think one thing that's different about America compared with other countries is that we just didn't accept that. I mean, people have through all that time, when the courts were saying, it's just a right of the militia to have a militia and so on, millions and millions of Americans read the Second Amendment and said, no, that's not what it means, and we don't accept it. And eventually scholars, and I'm going to use that word carefully because they were almost all practicing lawyers, not employees of law schools, started to dig into the history of the Second Amendment and found that it did not mean what the courts had virtually unanimously said it means, which was kind of almost nothing. And so that spirit of resistance to the court's fallacious interpretation of the Second Amendment happened because people understood that that the government was irresponsible in the amount of protection it gives. You can't count on the police. You know, when seconds count, the police are minutes away. And so many Americans understood that they just wouldn't accept the courts trying to abolish the right. And I think without that spirit, which has been manifested in many ways, I don't think the Supreme Court would have dared do what it did in the Heller case in 2008. In a way, this is a little bit like abortion. You know, the Supreme Court decided there's a right to abortion in 1973, and then in 1992, it said, okay, it's time to stop arguing. We've decided you just better get used to it. Then people just refuse. No, we're not going to just get, we're not going to get used to it just because you said so. You're nothing but a court. And we don't accept it. So I think the same spirit that has animated the pro-life movement is the same one that's animated what I would call the pro-Second Amendment movement.
I am pretty curious about gun-free zones and how those work into the Second Amendment, and how exactly who can be determined a gun-free zone, and how you get to be there.
Okay, I'm not sure I caught everything, but let me give an answer, and if it doesn't work, let me know. First, I think gun-free zones is a misnomer. They shouldn't be called that. They should be called helpless victim zones, because that's what they are. It disarms all the law-abiding people and lets the criminals pay no attention to this. A huge proportion of mass shootings, especially at schools, have occurred in so-called gun-free zones. And it's kind of common sense tells you, well, why would that be? Well, because the criminals know they're not going to be armed civilians there. So we just go in and shoot them like pigeons. So I think gun-free zones are the way they've been practiced are a really, really bad idea. And that the only gun-free zones that should exist are the ones of the kind that Justice Alito described at the oral argument in Bruin. One where you actually are as secure as you would be if you could bring your weapon with you. So a courthouse with magnetometers and so on, that seems fine. A school, no. No, not unless there's adequate security there, which there almost never is, as we've seen time and time and time again.
So how did schools get to? I'm curious though, how did gun-free zones in schools become normal? Like, how did that become the what everyone does, the rule?
Well, I think it got that way the same way so many utterly foolish laws get to be common. It sounds good. Politicians always have the urge to do something about every problem, even if they don't have anything they can actually do to solve it, so they'll do something symbolic. I think these gun-free school zone things and gun-free zone things are almost all just political grandstanding. And political grandstanding is a common thing throughout our political system, unfortunately. Global warming, they think they're going to solve global warming by building windmills. I mean, the examples of this are endless. And unfortunately, a lot of these stupid laws have really bad effects. That's true with gun-free zones, and it's true with a lot of environmental regulations. It's true with a lot of things.
All right, well, I could keep asking you questions. If we have some extra time at the end, sure, we'll get back. But I think we have to get to some audience questions now.
Well, thank you, Jewel and Jorn, and thank you, Tova. Those were all great questions. And we want to take a minute to recognize some of the students in our audience today. Terry Zalesnak has 3 homeschool students who are watching. Teresa Kukla has 37 students from Tabernacle School who are watching, and Cami Wanus has 1 homeschool student that is watching. In addition to all of our other audience members, we want to give a special welcome to our students who are watching with us today. So, Professor Lund, we do have some great audience questions.
Good.
Richard Hayden asks, are red flag laws unconstitutional under the Second Amendment? And
yeah, some of them may be. They're worded differently, and the primary objection to a lot of them is based on the due process clause rather than the Second Amendment, because ordinarily the government can't take things away from you unless it gives you certain legal procedures to go through with a disinterested magistrate of some kind. And a lot of these red flag things just say, well, if your brother-in-law goes to court and says, you're a danger, then you automatically get your guns taken away. Ultimately, what I think Second Amendment objections to the red flag laws are probably, and this is not something I've studied in depth, but I think they're probably going to come up in particular cases rather than as a general matter, because I think almost everybody agrees that there can be, in some circumstances, good reasons to disarm a dangerous individual. And so the Second Amendment objections, if due process is satisfied, then the Second Amendment objections may come into play in some cases. But I'd be surprised if the Second Amendment were correctly read to forbid all such laws, no matter how they're written. That would surprise me.
Okay. And just for anybody who might be watching who's not familiar with red flag law, that is referring, and I want to ask you if I'm correct, that's referring to someone saying that another person might be a danger to himself or others, or herself or others, and suggest going to court and asking that person's right to own a firearm be taken away, either temporarily or I guess until it's proven otherwise.
That's basically correct. Yeah.
Okay. Okay, well, thank you for that. And then Mary Bowler, along those same lines, asks if background checks are constitutional.
You know, the courts I think are certainly going to allow them. But one of the problems with this latest decision from the court in Bruin is finding how is that part of a historical tradition that existed when the Second Amendment was adopted. There was nothing like that at the time. I think in general, I give kind of the same answer as I did to the red flag laws, which is in some circumstances, I think background checks are fine. It's easy to imagine that the government would abuse the power to have background checks in such a way that would violate the Second Amendment. And I'll give an example of how this came up politically. At one time, you couldn't purchase a gun unless you got a background check, but the government was so slow in processing the background checks that you were deprived of your right to have a gun while they went through whatever procedure they wanted. And Congress ended up establishing the so-called Insta-Check system. So if you go to a gun store and you want to buy a gun, the gun store itself directly does the background check by hooking into the government's computers. And so there's no delay. Now, sometimes there's mistakes that are made, but there's no systemic delay or systematic delay. And, that political compromise is probably one that would satisfy the Second Amendment, at least as a general matter, I think.
Well, thank you. And then Reagan Grandy asks, how does the phrase, the right of the people to keep and bear arms shall not be infringed, relate to the preceding statement, a well-regulated militia being necessary to the security of a free state? Does the latter phrase relate to the former phrase, or are they different?
Well, I think grammatically, the introductory phrase about a well-regulated militia is what's called an absolute phrase. I don't know if they still teach sentence diagramming in fourth grade like they did when I went to school. But if you diagram the sentence, you have to draw a dotted line between the two phrases or two clauses. And the reason for that is that the absolute wording of a well-regulated militia being necessary to a free state does not modify. It's not a grammatical modifier of the main clause, the operative clause. which says the right of the people to keep and bear arms shall not be infringed. And so that's why you have to have some explanation of why that's on there. And these absolute phrases, they're sometimes referred to as ablative absolutes because the ablative case in Latin is what we use for that. They usually kind of say something about the background to the main clause or the purpose of the main clause and so on. And that's one of the things I think was kind of interesting about the Second Amendment. It gives you the impression that the purpose of the right to keep and bear arms is to lead to a well-regulated militia. But of course, if you think about it a little bit, that doesn't make any sense. You don't grant people a right. That's not how you cause a regulation, by giving people an individual right. So it's kind of the rhetorical force of that introductory phrase that I mentioned earlier. It kind of gives the impression this is about the militia, but grammatically, it just doesn't put any kind of limitation or modification, grammatical modification on the main clause.
Well, really interesting question and interesting answer as well. And we only have about 2 minutes left, and one of the things that you talked about today that really resonated with me was the spirit of the American people, and how when things just didn't seem quite right with some court decisions, that the American people educated themselves and knew the Constitution and researched and continued to press until the court saw things their way, or the court actually fell more in line with the Constitution. And that's why we do what we do here at Constituting America, is we encourage our listeners to know the Constitution and to get involved and to make your voice heard with your elected officials. And to that end, you had mentioned when we did our test about a website, SSRN, I believe it is, .com, where most of your articles are published, and you have written extensively on many jurisprudence issues. We know on the Second Amendment and also on many other issues as well. And you had mentioned that we can find all of your articles on this website. And Aubrey, I thought you might want to bring this up because I thought our listeners might like to know about it. It's ssrn.com. And there are many scholarly articles on this website. I guess you have to create an account and sign in. But Professor Lund, do you want to tell us a little bit about this, how we would use this?
Yeah, I should say not all my articles are on there. This thing came into existence after I've been writing articles for a long time, and the old ones aren't on there. And some of my shorter stuff I don't put on there. But I, the writer, like the other writers, my library posts this post these things on the website. All you do, and all of you young people know how to do research better than I do on the internet. But as you see there, you can just search. There's a search function, and there's an advanced search function, which all of you will know how to use. And you can search in various ways. And then, okay, so now you pulled up you pulled up articles by me, and if you look over on the left, if you go back up, you can say sort by downloads. You can sort by how many downloads there are. You can sort by when they were published on the site. And sort through things that way. You can also do searches within this body of paper. So you can do a search if you want to find only my Second Amendment papers. You can just search for Second Amendment. You can do that for and lots of people are now on this thing. So you don't have to go to a particular author like me. You can do these searches, through the whole, I think millions now of papers that are on here. And do the same kind of searches that you all know how to do better than I do on the internet using Boolean searches and so on.
Well, thank you. That is a great resource for us to know about, and we really appreciate you calling our attention to it. And we want to thank you for being with us today. This was a fascinating hour with you, and we really appreciate your insights and your very generous gift of time to our program. And I want to check in real quick here with Jewel and Jorn and see if there's any parting words y'all would like to give.
Great show. Thank you.
Yeah, we appreciate you being on today and sharing your knowledge with us.
Well, thank you for having me, and thanks for all the great questions. There wasn't a dumb one in the whole bunch, and they're all great questions.
Well, thank you. And thank you so much, Professor Lund. And we appreciate you. And we will hopefully see you back here again sometime.
Okay, I'd like to
Thank
do
you
it.
to our audience. We'll see you next week. We're going to be doing Amendment 3. So be sure and join us.